Hello everyone, welcome to A Level Law Help. In this video, we're going to be looking at the crime of assault. This is for the AQA course, but it is also relevant to other exam boards, so let's get into it. To begin with, we will start with a definition, and we will break our definition down into the actus reus and mens rea elements. So to be guilty of an assault, the defendant must intentionally or recklessly cause the victim to apprehend immediate and unlawful force, and this comes from the case of Ireland. Firstly, there must be an act or words for an assault, an omission, meaning failure to do something is insufficient. Some examples of assault include raising a fist, saying I'm going to hit you, pointing a gun at someone, or any other threatening gestures or words. Now moving on to what is meant by apprehend. To apprehend means to make aware of. The victim does not have to actually be in danger. For example, in Logden versus DPP, the defendant pointed an imitation gun at a woman as a joke. The woman thought the gun was real and was terrified. The man was guilty of assault despite the woman being in no real danger. The next element of the actus reus requires that there must be an apprehension of immediate force. This means the victim must be aware that unlawful force will occur right at that moment. However, it is sufficient if the defendant does something to make V aware that unlawful force may occur at some unpredictable moment in the near future. And the case for this is Smith versus Superintendent of Woking Police Station. Finally, words indicating that there will be no immediate and unlawful force can stop an act from being an assault. For example, in Tuberville versus Savage, the defendant put his hand on his sword and told the claimant, "If it were not assize time, I would not take such language from you." Because his words showed he did not intend to use violence at that moment, it was held that no assault had been committed, even though his action looked threatening. Now we will move on to the mens rea. The defendant must intentionally or recklessly cause the victim to apprehend immediate and unlawful force. Let's look at what this means. There are three common states of mind found in criminal liability. The first one is direct intention. This is the simplest of the three, and this can be defined as the defendant's deliberate decision to bring about a specific prohibited consequence through their actions, meaning the desired outcome is their primary aim or purpose. In other words, they did it on purpose and they wanted it to happen. And the case for this is Mohan. The next state of mind is recklessness, which is where the defendant knows there was a risk of the result happening, but proceeds anyway, and this was clarified in the case of Cunningham. Finally, there is oblique intention, meaning that although it wasn't the defendant's primary aim or purpose, the result was virtually certain to occur. So that is all for today. If you found this video useful, leave a like and subscribe for more A-level law content. If you want more law-related videos, check out my TikTok as seen on screen. Thank you for watching.